Hi, this is Victor. I am going to try to answer your bail questions. In doing so, I'm going to paraphrase Handbook for the Accused, the section on bail. First, what is bail? Bail is the court security to ensure that a defendant will appear at future court dates. It's a fixed amount. It may be $10,000, $50,000, $100,000, $1 million, but it starts out as a fixed amount that can be posted without further intervention from the court. Now, a common question is, do I have to post bail if I can prove I'm innocent? Nearly everyone has heard innocent until proven guilty, but this unfortunately does not apply when it comes to bail. A defendant may have the perfect alibi and absolute proof of innocence, but the court will generally not consider the strength of the prosecution's case when setting bail. Bail is initially set based primarily on the charges against the defendant, regardless of the strength or weakness of the case. Can the amount of bail be reduced? Yes, but there's a danger. Anytime you ask to reduce the amount of bail, the court may increase the amount of bail. The court can reduce or increase the bail upon the request of the defendant or the prosecution. When requesting a reduction, it's helpful to show that the defendant has strong ties to the community, such as home ownership, that they have multiple family members in the area, long-term employment in the area, involvement in the community. However, there's always the danger that when you request a decrease in bail, the court can increase it. What does a court consider in setting bail? Unfortunately, it's kind of up to the judge. There are guidelines by statute and by case law, such as the court is supposed to take into consideration the protection of the public, the seriousness of the offense charged, the previous criminal record of the defendant, and the probability of the defendant appearing when ordered to do so. The court can also consider other factors such as other outstanding warrants against the defendant, prior incidents that the defendant failed to make court appearances, the criminal record of the defendant, the location and type of the defendant's residence, whether an owner or a renter, the defendant's wealth, the amount of defendant's gain from the crime charged, the number of separate offenses charged. The court can consider any number of factors, and they don't even always state it on the record what they're considering. The defendant's status as a homeowner appears to be kind of a major factor, because if someone owns a home, they're probably not going to leave and abandon the home. What is cash bail? Cash bail means the defendant deposits with the court or the sheriff the full amount of bail in cash. For example, if bail set at $100,000, the defendant must post the full $100,000 with the court in the form of cash, cashier's check. Some courts and sheriff's departments also take credit cards or other forms of cash equivalent. What is a real estate bond? A real estate bond is posting with the court the value of the bond times 2 in the form of real estate. So you have to go out and get real estate that is, the equity in the real estate is double the amount of the bond. For example, $100,000 bond, $100,000 bail requirement requires the person to go out and get $200,000 in equity in real estate and then deed that real estate to the court. It gets rather complex, but the main point is it is double the value of equity, double the value of the equity compared to the bail. Okay. What is a bail bond? A bail bond is what most people use to post bail. They go to a bail bondsman and they enter into a contract between the bondsman, the defendant, and the court. The bondsman guarantees to the court that the defendant will make future court appearances when released. How much does a bail bond cost? The law generally sets the price of bail in California at 10% the value of the bond, the value of the bail. So if bail is $100,000, the bond's going to cost $10,000. Some bondsmen are able to offer premium discounts for things such as being a senior citizen, being in the military, union members, people who employ a private attorney. They have their own criteria, and I've seen bonds reduced as much as 3%. So on a $100,000 bail, some bondsmen will write the bond for $7,000. What is a bail source hearing? The court needs to be assured that the bail does not come from criminal activity. So a bail source hearing is where the person attempting to post bail shows to the court that the money came from a source other than the criminal activity. When do I get my bail back? If you post all cash bail at the conclusion of the case, you get it back. Do I get the money back I paid for a bail bond? No, no, no. This comes up all the time. The defendant will go in and make a small down payment to a bondsman. They may have a $100,000 bail. They sign a contract that says, I'm going to give the bondsman $10,000. The bondsman will take a small down payment towards that of $1,000, $2,000 and bail the person out. The case eventually gets dismissed, and the defendant is surprised to find out that they still owe the bondsman the full value of the premium. If they promise to pay that bondsman $10,000, they get nothing back, and they still owe the bondsman the balance of the $10,000. Well, what do you get back from the bondsman? The bondsman keeps the money that you paid for the premium, but when you have paid everything that's owed to the bondsman on the premium, the bondsman will release any collateral that he has. So if you've signed a pink slip to the bondsman, if you signed a trust deed to the house, if you've given any property, jewelry, other valuables to the bondsman will return that, or is supposed to return that, at the conclusion of your case after you've paid the full bond premium. What is a cosigner responsible for? The cosigner is generally responsible for everything that the defendant is responsible for. So if the cosigner signs on a $10,000 premium against a $100,000 bond, the cosigner is responsible for ensuring that the full $10,000 is paid. It gets a little scarier than that. If the defendant absconds, runs away, and the bondsman cannot find the defendant to surrender them to the court, the cosigner is responsible for the full value of the bond. If the bond is $100,000, the cosigner is responsible for the full $100,000. This isn't to discourage people from being cosigners, because from experience I've seen that most people who are bailed out appear in court. If they don't appear in court, they do miss a day every once in a while. They turn themselves in, the attorney surrenders them, the bondsman surrenders them, or it otherwise gets resolved without the bail being forfeit. Again, this is Victor, and thanks for watching.